hearing the reference by the Lord Advocate of the dissolution issued under paragraph 74 of Schedule 6 of the Scotland Act 1998.
Yes, Sir James.
I was moving on to the question where the requirements of Section 31 of the Scotland Act fit into the legislative structure I described yesterday. Section 31 was considered by the Supreme Court in UNCRC, and the relevant paragraphs for present purposes, just so we see what the effect of Section 31.1 and 31.2 are. If you go to page 914 in the electronic bundling, that should take you, I hope, to paragraphs 12 and 13. So page 914 in the electronics, 12 and 13 are the ones I want for present purposes. I'm just showing you the description of how Section 31.1 and 2 work. If I could just invite you to read 12 and 13 to yourselves, if you would.
Sorry, Sir James. The page again.
Page 914, my lord, I'm sorry. And it's paragraphs 12 and 13 when you get there. So as you see from that description, there is a distinction between 31.1 and 31.2, as the Supreme Court stated, or at least implied, based on the different language that is used between those two provisions. If the presiding officer decides that a draft bill is, or a bill is not within competence, the consequences are as described in paragraph 13. In other words, it wouldn't prevent the bill from being introduced, but it would be an important signal, as the Supreme Court put it, to the Scottish Parliament and the law officers considering a reference. However, a person in charge of the bill, if you go back to page 134 in the electronics, you'll have the text of section 31 itself. And you can see that the opening words of 31.1 were the subject of an amendment, as footnote 2 indicates, in 2012, so that it now covers both executive bills, if one can put it that way, bills presented by the Scottish Government, and it covers private members' bills, or the equivalent.
So what did it say before?
I think it said something like a member of the Scottish Executive.
Oh, right, okay.
But that's the nature of that change. But on the contrast, if a person in charge of the bill understood in that way is required on or before introduction, they're now required to state a positive. They've got to state that in their view, the provisions of the bill would be underlined within the legislative competence of the Scottish Parliament. And if they can't do that, they can't comply with the statutory duty. And our submission, which we understand to be common ground between the parties on this reference, the person in charge of the bill can't introduce it. They would effectively be inviting the Parliament to legislate on what they regard as an unlawful basis.
But the Lord Advocate has no role in
She doesn't. Under the statute, my lady, you're right, she doesn't. And I think the point was made by the President yesterday that maybe that both parties have put undue emphasis on the ministerial code, where what you're actually looking at is a statutory scheme. I mean, for the purposes of my argument, that doesn't matter terribly. But my lady is right. The Lord Advocate doesn't have functions under Section 31. The functions that she has arise as a result of the ministerial code, and are not, as it were, imported into 31.
You say that if a statement isn't made, the person in charge of a bill would be inviting the Parliament to legislate on an unlawful basis, but isn't there a middle position where they just don't know because of uncertainty?
My Lord, my respectful submission is that that's difficult under the structure of this provision, because they're required to state a positive.
Well, precisely, that's what I'm putting to you. If they can't state the positive, you said, well, that shows that it's, they believe it to be outside competence. But they may be in a position, indeed I think the Lord Advocate says she's in the position, where in view of all the background materials and arguments about the law, they just can't be sufficiently sure to state positively in the form of section 31.1.
My Lord, my submission is that this is a binary question. On its true interpretation, this is a binary question. And that indeed, as we understand it, is how it is approached by the law officers in Scotland. And so there could be a debate in theory. My Lord will be very well aware of the debate that rages within government as to whether or not you have a 51-49% standard, or you have a respectable argument or a stateable case standard. My understanding, at least from academic articles that are included in here and from the runes, so far as one can read them from the Lord Advocate, is that the standard that is applied is a balance of probability standard, a bit like the current government practice, at least, in relation to the HRA, when they make a statement under section 19(1)A. And so my submission is that what this requires does not leave open to the person in charge of the bill the option of saying, I'm a bit doubtful. They either can state the view or they can't.
Yeah, I appreciate this doesn't leave open that option. They can't say, well, I'm a bit doubtful, but let's try it anyway.
But your point is they wouldn't necessarily be inviting the Scottish Parliament to legislate on an unlawful basis because they may not be...
Yes, I mean, as I understand it, the almost thrust of the case against you on this is there may be a good, indeed it is said there is a good arguable case that such a measure would be within competence, but because of the uncertainty about that, the law officer, and I assume the minister acting on their behalf, conscientiously feels they can't make the positive statement required in section 31.1, but then it may still be the case that in truth, if the matter were determined, this would be within competence. And the effect of this position is that because they can't state positively their view, even though they may believe that there's a good arguable case for it, that good arguable case is never tested.
Yes. And my submission is that that's the way in which the Act is set up. The Act is set up in a way that requires, as a precondition under the statutory scheme, the positive statement from the law officer. It doesn't allow for the position in which the bill can be introduced, even in circumstances where the law officer is not able to make that positive statement and thereby to comply with the duty that's imposed under section 31.1.
But if the Lord Advocate is able, under paragraph 34 of Schedule 6, to bring a reference to test that very issue, then in light of this court's ruling one way or the other, it may be possible for a positive statement then to be made under section 31.1.
It may be, and that's the debate. But that's the debate that you're having to resolve. Ultimately, that's the interpretive debate. Does the Act allow for that possibility under paragraph 34? And that turns fundamentally on the reasoning, on the proper and true interpretation of the tailpiece wording in paragraph 1F of Schedule 6, or is the position that ultimately the structure of the Act doesn't allow for that, and that this provision, 31.1, requires a statement to be made, and if it can't be made, then the bill can't be introduced and the position will not be tested. I quite understand that the case against me says, well, legality suggests that it would be better if the court were allowed to test that in a case where there was doubt in the mind of the law officer or of the person in charge of the bill.
Yeah.
My submission ultimately is you can't get there because that does too much damage to the structure of the Act. But my Lord is right, ultimately that's the issue between the parties.
Yeah, I mean, I just wanted to press you on this, which may be important. I mean, you make the point about legality, which is one of the points made against you, but isn't there if you like, a democratic argument as well, that it may be that truthfully, as properly construed authoritatively by a court, there is competence. Yet, because of the context in which they're operating, a minister and the Lord Advocate at the moment feel that they can't make the positive statement in section 31.1, and so the bill can't be introduced. And so it might be said, in order for the democratic authority of the Parliament to be engaged, where they do have competence, I'm I'm not indicating any view on the merits here, but just in principle, there may be competence. One might expect that not just the principle of legality, but also the principle of democracy would suggest that paragraph 34 should be read sufficiently widely to allow this sort of application.
Well, my Lord, you've already had my response at least to a part of that question, which is, so be it, this is the structure of the Act. My answer directly to the democratic way of putting the legality point is that you can see, and this will depend on the strength or otherwise of the submissions I'm about to make on the true construction of 1F and how it all hangs together in toto. But if the position is that on the true construction of this Act you can't get to that place, then that provides you with the answer to the democratic question, because Parliament has decided on a true interpretation which is for the courts, of course, but Parliament will then have decided that if a person in charge of the bill is not even able to say to the requisite standard, assume it's 51%, that the bill will be within competence, then a bill simply can't be introduced. And the justification for that in policy terms, if one's looking at it from that perspective, legislative policy terms, is that Parliament has decided that if that hurdle cannot be surmounted, then the court shouldn't be troubled with those issues, and that's an integral part of the structure. But I fully accept that that depends upon all the other indicators to interpretation that are going to bear on, in particular, the question whether those words in the tailpiece of 1F can work in the way that my learned friend needs them to, so as to tee up a 34 reference to get you, the courts, into that question.
Yeah, thank you.
I've been thinking about it just as an illustration, the animal defenders case, where the minister introducing legislation in the UK Parliament providing for a ban on political advertising did not feel able to make a Section 19 statement that the bill was compatible with convention rights.
Yes. And it went off to Strasbourg, and
the issue eventually went to Strasbourg and was decided, I think, 9-8,
yes,
in favour of the compatibility of the legislation.
well, yes.
What might be thought to be anomalous about Section 31 on your interpretation of it is that the final arbiter of the competence of the Parliament
is the person in charge of the bill and not the courts.
Exactly.
So as to exclude the animal defender's possibility.
Yes.
My Lord, I take the point. It's another way of expressing the same thought that I suspect my Lord Sales was putting to me.
Yes.
And my answer to the direct point my Lord puts to me under the HRA is that the structure of Section 19(1)(a), to which you will need no introduction, is rather different to this. And so the question whether you end up with that anomaly, if that's the right way of looking at it, is ultimately still a question of statutory interpretation. And under the HRA and Section 19, that scheme is very deliberately set up in that way, because as you will recall, A is yes, B is no, but on either event they can put it to the House. They just have to put it to the House with their feet to the fire in terms of compatibility if the answer is no. So that's absolutely squarely built into and clear from the structure and the relevant provision in the HRA. So I think that's my direct answer to my Lord's point about the animal defenders litigation. But of course, my Lord is right that it tees up the broader question that my Lord Sales was.
But doesn't that question arise anyway, because compatibility with the convention is also, isn't that also something that the person in charge has to be
They do under
satisfied
29(2)(c).
But that's not something that the Lord Advocate says can be referred to the court because it's not a reserved matter. So
Yes.
even on the Lord Advocate's case, I think that anomaly might still...
It will, and that's going to be central, you won't be surprised to hear me say, when we come to 1F and working out what the meaning of that is and how it coheres with the structure of the Act, which is ultimately going to be determinative of the issues that we're now discussing, which is whether or not 31(1) is to be construed in the way I suggest or not. That is going to be a pretty important point. But can I develop that when I get to that bit of
Yes,
it? It's going to be more logical to do it now.
could I also flag up that in your answers to my Lord Sales and Lord Reed, you slightly elided the Lord Advocate's inability to come to a view with the person in charge's inability to come to a view. And that's an aspect that concerns me as to whether there's an oddity with the Lord Advocate being able to make a reference if the bill is being introduced by a minister, which then confers on her the role on which she seems in some respects to be relying, but that role doesn't arise
if it's a person in charge of a bill or the minister.
Yes.
Yeah. Well, my lady, I think in answer to that, I think the only thing I would say, which I know you're very well aware of already, is the point I made earlier, which is that this has got to be the view of the person in charge of the bill, and the ministerial, the Lord Advocate's role in relation to that is, as it were, behind the scenes in relation to a relatively narrow category of case. It might well give rise to at least the oddities that my lady draws attention to.
I'm not sure that's such a problem, is it? I mean, if a minister was in a state of uncertainty, and I think you're right to focus on the words of section 31(1), which points to the state of mind of the minister in this case rather than the Lord Advocate.
You'd still have the same drama.
You still have the same problem, and then it would be open to them to go to the Lord Advocate and say, I think it's arguable, I would have difficulty conscientiously saying positively that that's the position, that it ought to be tested. Please, can you now, if it's available to you, operate the mechanism under paragraph?
The same issue would arise.
The same issue, yeah.
I fully accept that, and indeed you can posit myriad different hypotheticals. They don't like the view of the Lord Advocate, they feel able to disagree with the view of the Lord Advocate, or they decide they don't like the view of the Lord Advocate, so they're going to go to someone else and get a second opinion on the particularly fraught issue, all of those. But I entirely accept it doesn't terribly matter how you get there. The problem to which the issue of interpretation ultimately gives rise arises whenever you have a situation where the person in charge of the bill is doubtful about competence.
And the points you just made about them seeking advice from other people, almost talking it around until they find someone prepared to give them the right advice and then making the statement. I mean, doesn't that, if you like, underline the importance of having a mechanism in an appropriate case of coming to a court to get an authoritative ruling on that very point, rather than just leaving it to the vagaries of what the minister might think and who might be prepared to give them legal advice that they want to hear?
Well, my lord, if you took a cynical view of that process, then that may well be a fair point. I was looking at it from a slightly different perspective, which says you can legitimately go and test a view, and the view of one law officer may not necessarily coincide with the view of someone else. So, but
I'm pressing on this because
you are, because you want an authoritative view from a court.
Yes, absolutely. I mean, it's such a fundamental point.
Yeah.
It might be said that it seems a bit strange that you can't get an authoritative view of a court on that issue, and it all depends upon what the minister happens to think or who he can find to advise him.
My lord, I accept that there is, of course I accept that there is that point lurking, as it were, against my submission, because my submission has to be, and is, so be it, in relation to 31(1). The question is there a sensible, proper, interpretive route that leads to that outcome? Or is the position that Parliament has been big and bold, as it were, in relation to this particular bit of the structure? And my submission is that that's exactly what they've done, and you can see that because the myriad difficulties that exist with trying to interpret the tailpiece words in 1F to do the job that my learned friend needs them to do to get you that outcome. Yeah. But I'm not shying away from the attraction, and of course one sees it forensically, particularly in this court, of a point that says otherwise you're not going to get an authoritative view from a court, you're going to get in effect a final view from an executive person that might be doubtful. Of course I accept that that's a question that needs to be grappled with, but that's why we're in the interpretive game we're in. Yeah. That's why we're going to the points that I'm going to go to. So I hope that doesn't shy too far away from the point I was putting away. So, I was on section 31(1) and I'd explained or sought to explain how the thing works and that difference or distinction between 1 and 2. And 1 throws up the issue, 2 really doesn't, because it's just a view and then people can decide what they want to do about it, law officers referring or Scottish MPs voting in relation to the bill. But I do submit that that structure, particularly on our conception of it, 31.1, is an important part of what the court described as the pre-legislative safeguards that exist in this bill, and the expression of a view, the ability of the law officer or the person in charge of the bill, I'm not going to keep eliding those, the person in charge of the bill, the ability of the person in charge of the bill, on advice or not, to make the positive statement is an important part of the safeguard. And my submission ultimately is that the existence of 31.1, and we've rather explored this, does not enable, through Schedule 6, paragraph 1F, the person in charge of the bill or anyone else to bypass, because that's what would happen, in effect, the careful structural preconditions and temporal preconditions to a reference in relation to draft bills or past bills that are set out in the Act that I took you through yesterday. And I wanted to make 5 initial points before coming directly to the true interpretation of the tailpiece wording in paragraph 1F, if I may. So 5 initial points, if I may, on that. Firstly, the Act recognises the starting point that I went to yesterday, that courts don't normally rule on inchoate pieces of legislation or ideas for legislation, and there are powerful reasons of principle for that starting point, and then deliberately sets out a careful regime, all of which is plainly designed to get a bill before it gets to this House, to this court, designed to get a bill to a state of finality immediately prior to consent. Or assent. I went through all of that detail yesterday, and I don't repeat the detail of it. We submit it's entirely consistent with the structure and terms of the Act to interpret 1F in a way that does not allow that to be undermined or bypassed. And on that basis, 31.1 is a precondition, and as such is simply a part of the pre-enactment safeguards that Parliament has seen fit to put in place. That's the first point. Second point is that the United Kingdom Parliament were evidently concerned to ensure, in section 31, that the responsible people, i.e. the people in charge of the bill, consider and pin their colours to the public mast on competence. It is for the person in charge of the draft bill to form that view. It's their responsibility, legal and political as it were, under the scheme of the legislation. And it isn't, we submit, a responsibility under the scheme of this Act, which is simply to be farmed out to the Supreme Court with an invitation for them, in effect, to provide advice to the person in charge of the bill and or the law officer. Thirdly, the logic of the Lord Advocate's position as to the meaning and effect of 31.1 and the related issue of the meaning and effect of paragraph 1F in its tailpiece wording is, we submit, uncontrolled and surprising. If 1F in its tailpiece wording does allow for the self-same issue to be referred, i.e. the self-same issue that could be referred under section 33 as a reference once the bill had reached finality, if that's the position, truly, where is the limit on her case? Suppose the Scottish Government have an early draft of a bill. Suppose the Scottish Government are thinking about introducing a bill that might be in something like this form. What if there isn't a bill at all, and they simply have an abstract legislative policy idea? At what stage of formulation of that abstract legislative policy idea does the 1F wording cut in to allow the paragraph 34 reference? How developed does it have to be? And of course that's a critically relevant question because of the very structure that leads to the section 33 reference designed to ensure finality of bill before court ruling. And you will note in that respect the enforced pause in section 32.2 of the Act on page 137, the presiding officer cannot submit for assent a bill which has been referred under section 33. That doesn't apply to a paragraph 34 reference on the Lord Advocate's case. So if shortly after this reference, a backbench MSP felt able to introduce the bill because he was marginally less squeamish about the idea of competence than the Lord Advocate entirely properly is, it could be debated and passed whilst all the while this reference under paragraph 34 is going on. One can multiply the questions. If paragraph 1F allows for the self-same issue to be referred at any stage, is it said, and this was the subject of some probing questions yesterday, is it said that that would be allowed or permissible even after introduction, but before passing? And of course the sting in that particular tale is that after introduction you're even more squarely within the legislative processes that lead up to the paragraph, to the section 33 reference. But is that possible? And the Lord Advocate yesterday took what we submit to be the surprising stance that it could apply a paragraph 34 reference even during the course of its passage through the Scottish Parliament. And we say you couldn't have a starker indication than that as to the extent to which her argument therefore undermines the careful delineated process that leads to a section 33 reference.
I mean, so far as that is concerned, I mean, there is another control mechanism, which is the discretion of this court whether to entertain a reference.
That's going to be my fifth point. Is it adequately controlled by the Lord Advocate's discretion and or the Supreme Court's discretion? Can I come to that in sequence?
Your point is that if it's right that a paragraph 34 reference can be made even after the bill has been introduced, then 32(2) doesn't seem to preclude it getting royal assent whilst the matter is pending before this court.
Yes, and that preclusion, that preclusion doesn't cut in the same way. And there's a broader point, which is look at the trouble that Parliament went to describe what has to have happened, including through the standing orders process and all the bits I took you to yesterday under 36(1). Look at those detailed processes, they all get swept away. And you've got to answer the question in principle, well, where is the control? At what point, before or after introduction, the same essential problem arises, which is that you've got to grapple with what the principal distinctions are. After introduction, it's a slightly different one, because you're obviously cutting across the processes that Parliament has laid down. If you do it before introduction, you've actually got to grapple, in my submission, with the question, when principally does that stop? When, as a matter of principle, does it stop the 34 power on the Lord Advocate's case? And of course, on their logic, if 34 works, you could simply refer the matter even if it was a pretty hopeless argument on competence. But there's a kind of merits point there. Now, again, my Lord Salisbury may say to me, well, that can be controlled by the discretion of the court. If it's ultimately and obviously hopeless, then we'll step in and fix it.
If a backbench MSP introduced a bill and was debated and passed, whilst a reference was going on, surely in practical terms, the Lord Advocate would then trigger the delaying mechanism under the legislation by making another reference in relation to the act as the bill as passed.
Possibly, possibly not. And it would depend upon the timing. But one's got to make it work. There may be tools there that might mitigate some of the worst excesses of this, but it's difficult to see how it sits coherently and squarely and faithfully with the scheme of the legislation that Parliament has set up, I submit.
But where a reference is made under paragraph 1A of an act, then presumably the act continues in force and in operation pending this court's decision.
It does. And we place reliance on that when we get to Schedule 6, paragraph 1, because there's a specific reference to enacted legislation. Again, not to multiply the questions absurdly, but one could, on their logic, be referred, even if there's no bill at all, not even a proposal to legislate in a particular way. And that would drift towards setting, as it were, entirely hypothetical questions into the lap of this court under paragraph 34, inviting them to rule on legislative policy. And again, I come back to it, part of the constitutional difficulty with that, unless you can find a clear distinction and line and cut-off point, is that it does risk, as it were, dragging the court into the political process, which the structures that the Act sets up are assiduous to avoid, because all of the democratic processes have already happened. The only thing that remains is the King's chop on the piece of legislation that has otherwise gone through the democratic processes and in part. That's the democratic attraction of that structure. And so one does need to be wary, or at least to balance against the democratic points that my Lord Sells was putting to me. One needs to balance that democratic feature, which is inherent in the very structures of the Act. But one also notes finally, and I promise this is the last point on this particular contentious way of putting the argument, but one notes on the logic of the Lord Advocate's case, it would be open, perhaps surprisingly open, to the other law officers, the law officers who are, as it were, representing the UK Westminster aspect of this. It would be open to the AGS or to the AG to refer at any and all of these early points in the development of legislative policy by the Scottish Government. That seems inherently unlikely as an intention to impute to the UK Parliament. Might be thought to be as unlikely an intention to impute to the UK Parliament as it would be unwelcome to the Scottish Government itself, were that truly to be the position. But why isn't that the logic of the Lord Advocate's case? And the only way in which the Lord Advocate seeks to escape from that, no doubt, unattractive consequence of her argument is to say, no, we don't need to worry about that, because it's only the Lord Advocate who can refer under 34, because it's only the Lord Advocate who would have the function under section 31. But of course, that's a hopeless argument, because the function under 31 is not hers, it is the person in charge of the bill. So that can't possibly be right. But in any event, it doesn't matter whose function it is on her case. The question only is whether or not Schedule 6, paragraph 34 is triggered. And if it is triggered, because there is, for the sake of argument, doubt about competence under Section 31, and the Section 31 statement is problematic, or you're at an earlier stage, then all of the law officers under 34 have the option, or none of them do. It can't depend upon the Lord Advocate being involved or engaged in the function under Section 31. So, for those reasons, we do submit, unaddressed, I would respectfully add, by the argument that is mounted by the Lord Advocate, for those reasons we do make as a third submission the point that the logic of her position is, as I put it earlier, uncontrolled and surprising. Fourthly, to touch on a point we've, and I can take it very quickly because we've touched on it already, there is, we submit, no unacceptable democratic or legal lacuna. This isn't a situation in which something with legal effect has occurred, but whose legality could not otherwise be brought before a court. And for that reason, it's nothing like the Jackson case, which I think was relied on in the Lord Advocate's case. To the extent that it follows that this draft bill, or a draft bill like it, or legislative policy, if you're in the same position, would never be introduced or come to fruition, so be it, is our answer to that. There is no reason to suppose that the United Kingdom Parliament would have intended Schedule 6 to be used as a vehicle for that sort of issue in circumstances in which the person in charge of the bill was not, and I would say not even able to offer that positive statement on competence. And it is, we would note finally just on that point, it isn't as though the Lord Advocate in this case cannot answer the question in 31.1. The difficulty is that she can answer it and has done so. And the problem for her is that the Scottish Government do not like the answer that she has given on competence. she is not able to form a view with a sufficient degree of confidence that the bill which is proposed would be within competence. There is no difficulty with answering the question. The difficulty here is with the answer. That comes to the fifth point, which touches the point that my Lord Sells was raising with me a moment ago, which is all of this, or can all of this adequately be controlled by reference to either the Lord Advocate or presumably the other law officer's discretion in deciding when to make a reference to this court under paragraph 34 if she has that power, or the Supreme Court's discretion in controlling, for example, bills that are obviously outside competence and in relation to which there's really no acceptable issue. Of course, we recognise that there is something of a filter in paragraph 34 because the references can only be made by a law officer, and one would expect as a standard that law officers will behave in a responsible way, and that makes it to some degree less likely that the procedure would be misused. But our submission is that even if exercised in good faith, there is no reason why the United Kingdom Parliament would have intended to afford that power to the law officers to cut across the wider statutory scheme in the way that would be entailed. And we do note that the section 34, the paragraph 34 power has been used in the past in circumstances in which the Supreme Court thought that such a reference was inappropriate. You have in the opening segment of the authorities bundles the two Northern Ireland references, which you'll be very familiar with. They start at page 866. I don't invite you to turn them up now, but from 866 and then 874 onwards, you've got those two references. And the court did exercise that discretion. And so far as the Supreme Court discretion is concerned, my submission is that what one is truly seeking here is an answer from the terms and structure and nature and purpose of the Act. One is looking for the correct interpretation so as to divine Parliament's intention in relation to this particular legislative scheme. And of course, the Supreme Court will be concerned to ensure that any discretion which it had when it exercised it was being exercised in conformity and faithfully with that structure. We also note that although, of course, in those Northern Ireland references, the Supreme Court discovered that it had a discretion, and I don't for a moment cast any aspersions on the omnipotence of the Supreme Court to discover procedures or discretions that might assist it to avoid abuse of its procedures, nevertheless, there isn't an obvious Supreme Court discretion built in for this purpose or at all to the Act. So you've had to search for the source. I don't denigrate the search for the source is obviously there, but you've had to search for the source outside the four corners of the Act is the short point in relation to that. So although, of course, I accept that the Supreme Court has discretions to control particularly abuse of its own procedures, that only goes so far, I respectfully submit, in answering or assisting to answer the question what this structure with these provisions actually means. So with those five initial points...
Paragraph 34 follows on from paragraph 33.
Yeah.
Which presumably must, devolution issue has to mean the same thing in both paragraphs.
Yeah. The distinction between 33 and 34, as my lady sees,
yes,
is
that where the proceedings
exactly
are not. Right, but I suppose the cases that you referred us to yesterday would suggest that it would not be possible in proceedings for an issue as to the legislative competence of an inchoate bill to be raised.
I think that would be
be
very difficult, because it'd be difficult to see what the law would be. It's rather the point made by the Lord President in Keating that a draft bill has no legal status. And that's why these provisions, the section 33 reference procedure, is an exception to the general rule. So they've had to make these other provisions, including 33 and 34, which sit together in the way you indicated. Can I turn then to Schedule 6, paragraph 1F? And I do so, of course, recognising the force of the point that I know the Lord President was interested in, which is when you just take the words as they sit, they look like big, broad words, particularly when you take into account the fact that arising by virtue of, or by virtue of, is a defined term under 126, as meaning by or under, I think, from memory. How far that adds to the interpretive sum is a more debatable question, but the words on their face look like big, broad words, so why wouldn't they work to give effect to legality and all the points that we were discussing a moment ago on that front? But we respectfully submit that despite their apparent breadth, they do need to be interpreted in the context of the scheme of legislation in which they sit, and I wanted to make 4 remaining submissions as to the true meaning and effect of those words. First, I state but do not repeat all of the points I've made earlier about cutting across the legislative scheme in relation to draft bills and the care which Parliament has set out in relation to that. It might also be noted that the Lord Advocate's interpretation of 1F also cuts across the provision in the scheme for who determines legislative competence before royal assent. If the question of legislative competence of a draft bill is a devolution issue under 1F, the law officers can institute proceedings for its determination under paragraph 4 of Schedule 6, see page 326, paragraph 4 of Schedule 6. There is no requirement or even provision in the Scotland Act for paragraph 4 proceedings to be instituted in the Supreme Court. Back to my Lord Reed's point about this is an original jurisdiction in the Supreme Court, and there's a constitutional reason for that in the Scotland Act. But if it's a devolution issue, why couldn't it be the subject of proceedings under paragraph 4 in ordinary proceedings, not to this court? And of course, law officers do have the power, which I was just discussing with my Lady Rose, they do have the power under paragraph 33, as it were, to divert such proceedings to the Supreme Court. But it doesn't require them to do so, and that would depend upon law officer discretion, which feels like a pretty odd consequence. The broader significance of this cut-across point is that it renders it highly unlikely, we submit, that Parliament intended to undo all of those careful controls in relation to timing and draft bills and getting them to finality and all of that by general tailpiece words in Schedule 6, paragraph 1F.
If the Lord Advocate's reading of paragraph 1F is correct, then is the implication of paragraph 4 not that she could indeed have brought proceedings in the Court of Session
Yes.
seeking a declaratory order?
It is. That's my submission.
And why do you say there's a problem with that?
Well,
apart from your, why specifically about that? Is there a problem with that procedure?
there's no difficulty with a procedure that ends up in the Court of Session which will give wonderful judgments as soon as it receives the issues. The problem that arises in relation to this Act, sorry to sound like harping on the same theme again and again, is that it makes specific provision for draft bill issues to come to this court directly.
Yes, I see. So it would obviate.
It would obviate. Well, it wouldn't entirely obviate it.
33.
I don't want to overstate it because paragraph 33 allows the diversion, but it's a discretionary diversion rather than a mandatory reference process per section 33. Yeah. That's the short and small point. And I mean, the difficulty is that the more you multiply all of these issues and these processes, the more force there would appear to be in the view offered by the Lord President in Keating's, particularly at paragraph 61, that if essentially the argument that my learned friend the Lord Advocate is running is right, that would be, as he put it, a recipe for chaos, rendering the careful structures under the 1998 Act redundant. That's the first point.
You say Keating's was wrong in if paragraph 4 does entitle the Lord Advocate to refer this devolution issue to the Court of Session, where does that leave the decision in Keating's?
My Lady, the answer is it doesn't undermine the decision, because the decision was ultimately taken and rested upon the application of the standard principles that I went through at the outset about academic appeals, and there were too many imponderables, thought the Lord President, to be dealing with that issue now. But my lady, in fairness, is right to this degree, that if my learned friend, the Lord Advocate, is right, why wouldn't it be said, or why shouldn't it be said? Well, there's the kind of paragraph 4 thing. It wasn't necessarily the Lord Advocate who brought it on a reference, but you could get to that same place, and then she would say it's not an academic issue at all, because what paragraph 34 envisages, back to my incoherences argument, is that you can refer a legislative policy idea that has just clicked into the head of the First Minister if it bears on competence and you're doubtful about what the answer is. So there is an oddity there, I respectfully expect. Anyway, that's the first point, the cutting across point. I don't seek to labour it any further. The second point is that if the Lord Advocate's position had been the intention of the United Kingdom Parliament in making the Scotland Act 1998, in other words, the setting up of alternatives at the choice of, for example, the Scottish Government, one would expect, I respectfully submit, one would expect to see that intention very clearly expressed in Schedule 6, paragraph 1. Not merely would you expect clear words to give effect to that because of the cut-across point, but you would expect Parliament to grapple with how this sort of reference might work with and relate to the processes that are specifically directed at draft bills under Section 33. So you expect Parliament legislatively to grapple with that interface. And it might be thought that it's all the more surprising that this is designed as a tailpiece set of wording to cover draft bills and legislative policy ideas in circumstances in which, if you go to page 322, so you have paragraph 1 before you, and it's a point that you've already picked up on, I know, but in a slightly different context, it's all the more surprising, we submit, given that the paragraph 1 at sub A does in fact deal with legislation, not with draft legislation, but with legislation itself. If it's going to deal with the legislation itself, why doesn't it deal with draft bills, particularly given that Section 33 contains all of the processes and 36(1) sets out the democratic processes that have to be gone through before you get to a stage of a 33 reference. All the more surprising, we submit, therefore, given that legislation as a concept is covered in 1, that this is not dealt with clearly and specifically. Whereas, of course, given that 1A does deal with enacted legislation, that sits entirely coherently with a scheme that is designed to set detailed pre-enactment safeguards and reference procedures in relation to draft bills. There's nothing problematic with that. What this is doing is making provision for reference of devolution issues in circumstances where the Act has already become law and continues to have legal effect. Moreover, it's intensely surprising for a slightly different reason that it isn't dealt with specifically if the Lord Advocate is right, because there is nothing at all in paragraph 1 about bills or inchoate legislative proposals, depending upon how far the logic of the Lord Advocate extends. There's nothing in there at all, despite the fact that proposed things, if I can put it generally, are indeed dealt with as proposed things in paragraph 1. See, for example, sub B, a function which a person has purported to or is proposing to exercise. C, proposed exercise of function. D, proposed exercise of function. So why not proposed legislation? So they're covering all the subject matter, but they're not covering this. So you have to assume that the parliamentary draftsman is in effect ignoring the elephant in the room. That's the second point. The third point is perhaps a bull point, I respectfully submit. The Lord Advocate's interpretation of those tailpiece words we submit does not make sense in the structure of this Act. There is a substantive aspect to that submission. Their case is effectively that the Section 31(1) inability of the person in charge of the bill to make a statement, a positive statement of the kind envisaged by that section, gives rise to take the wording of 1F at the tailpiece, a question arising by virtue of the Act about reserved matters. And they say it's important that that should be able to be referred under paragraph 34, because otherwise competence issues preventing the introduction of legislation with all of the democratic and legality issues to which my Lord Sales referred would arise. That's the case. The difficulty with that case, as a substantive proposition, is that the tailpiece refers and refers only to reserved matters. And that does not square with this core purpose for which the wording is said by the Lord Advocate to exist. There could be, to put the point in a slightly different way, precisely the same inability or doubt about whether that statement could be made as a result of any of the grounds that are set out in section 29 sub 2. Page 129. The person in charge of the bill could be unable to make that statement or doubtful about that statement because, for example, they were doubtful about whether or not the draft legislation would be or would not be incompatible with ECHR rights or would be a breach of restrictions under Schedule 4. Yet on her case, they couldn't refer in reliance on paragraph 34 because paragraph 34 is restricted to reserved matters. And my learned friend, the Lord Advocate, was tellingly unable, in answer to the direct question posed by Lord Sales yesterday, to which he promised to return but didn't, to provide any reason why, if she is right on the interpretation of paragraph 1F, Parliament would or might have chosen to draw that distinction. It cannot be said that there might be an explanation for that because reserved matters are more fundamental, which is, I think, a prospect possibly floated by Lord Sales saying, well, I thought you might be saying that. That can't be the position because there is no hierarchy in 29(2) of importance. And that inability to answer that question in any sensible or coherent form, we respectfully submit, is nigh on fatal to the suggestion that the wording was designed to cover what she needs it to cover. What this indicates is that Parliament cannot have intended that set of wording to be a catch-all picking up within the language of paragraph 1F doubts about a section 31(1) statement with all the preconditionality that that entails. If that had been the intention, put the submission in a sentence, if that had been the intention, why doesn't the tailpiece wording in 1F refer to competence? That's a substantive difficulty, and I will come as my fourth and final submission to the wording, back to the tailpiece wording, to say what we have to say positively about the explanation for why reserved matters and reserved matters only is referred to in that paragraph. But I just wanted to touch on a procedural incoherence, if the Lord Advocate is right, to go with the substantive one I've just described. And of course, this procedural incoherence arises only if one could get past a position in which the person in charge of the bill is unable to make the statement. But on that basis, if they were able to get past that, then competence issues that could or would be referred under section 33 could then include and do include broader questions going to competence. For example, the restriction in Schedule 4 paragraph 4.1 that the court considered in Continuity Bill and then in UNCRC about making modifications or not making modifications to various delineated or listed acts. Yet on the Lord Advocate's case, you would have to have two stages in such a case. One to consider the reserved matters under 1F, and then, if the bill could still be passed, under a subsequent Section 33 reference, raising other matters that do not fall within the concept of reserved matters but might fall within, for example, Schedule 4 or human rights, whatever it may be. And that is a procedural bifurcation oddity, to put it at its very lowest, with all the disadvantages of a split procedure, and no doubt that was another part of the Lord President's view about the recipe for chaos as expressed in Keating's. And again, I don't seek to and don't need to go as far as to say that there aren't some parts of that that couldn't be controlled by the exercise of judicious discretion by the court, but it isn't and can't be a complete answer to the issue of interpretation which is raised. That procedural oddity, and we would put it higher than that, but that procedural oddity, to put it at its lowest, is a serious substantive procedural, rather, incoherence in the Lord Advocate's case. So the fourth submission in relation to 1F and the tailpiece wording then is that they do have a straightforward and evident purpose, that is, referring to reserved matters only, without seeking to import the breadth and the controversy, if I can use that single word to incorporate all the earlier submissions, that the Lord Advocate's case entails, including the dissonance with the various careful structures under the Act. Our submission is that the evident and core purpose of paragraph 34 and paragraph 1F in the tailpiece wording is to permit references of groups of issues that might bear on legal provisions in the enacted legislation or public functions that plainly arise by virtue of the Act. The Lord Advocate mentioned yesterday that this tailpiece wording was inserted by amendment during the passage of the Scotland Bill, and she is right about that. We've looked back overnight at Hansard and have found little or no real assistance on the issues that you have to confront there. It was simply described as being one of a suite of technical amendments, as it was put, so not much assistance from that. But if I can go with a little temerity, as at least, if I can go to the explanatory notes that you have starting at page 365 in the bundle, I wanted to take you to one bit. I, of course, accept, I should interpolate to say, I, of course, accept that the explanatory notes of the Scotland Act were rather unusually produced in 2004, some years after its passage, so we're not in the usual contemporaneous document to which the United Kingdom Parliament will have had regard during the passage of the bill. That doesn't render them inadmissible for this purpose. It just gives them, as it were, reduced weight. This was a point considered by Lord Hope in Imperial Tobacco at paragraph 33, page 646. But it's quite sufficient for my purpose here, because I'm only drawing attention to the explanatory notes as a helpful collation of examples of when 1F in both of its parts might be used. So there's some assistance to be derived from it then. I should also add, sorry to interpolate some more, but I should also add that the document produced contemporaneously with the Scotland Bill when passing the Act of the Scottish Act, the Scotland Act, was called Notes on Clauses, and they are what one would normally call explanatory notes. And Lord Hope, of course, recognised the value of their interpretation in paragraph 33. We have placed a little weight on those notes of clauses in our case at paragraph 22 for a slightly different purpose, but the core point for present purposes is that those notes on clauses don't address the tailpiece wording in 1F and so aren't available to assist you as an interpretive tool for that purpose. I wanted with that caveat and recognition of the caveat as to the status of these explanatory notes to take you, if I may, to page 379 in the electronic bundle, which are the notes that deal with subparagraph F of paragraph 1 of Schedule 6. And you see that structure. The relevant paragraph for this purpose is the first full paragraph, perhaps the second full paragraph, sorry, or subparagraph, indented paragraph at the top of the page.
I'm wondering if you've given us the right page reference.
379?
This begins the Parliamentary Constituencies Act 1986.
Oh, maybe perhaps mine have got out of... Have I got out of kilter? 379?
I beg your pardon. I'm looking at the wrong bundle.
I'm sorry, my lord.
No, it's my fault.
So 379 should start with subparagraph E.
Yes, I'm with you now.
So drop down from E to F. That's the invitation. And you will see that the only example that's given, in effect, of something which deals with the tailpiece wording is really the last line and a bit of that subparagraph, or whether the functions of a body relate to a reserved matter, C1263, as an example of a question falling within the 1F tailpiece. Yes, of course. My learned friend Mr. Hickman has intervened at this stage. And the third line, which is to draw your attention to questions swept up in this subparagraph, can arise in various circumstances. Very happy to draw that to the court's attention. But I wanted to look at the example that is given there. 1263, you have on page 155. If you just flick back to that, you will see from that provision, page 155 in the electronics. Sorry to jump around a bit. Just wanted to show you the bit that's being referred to. It's in the interpretation section. Sub 3, for the purposes of this Act, the question whether any function of a body, government department or office holder relates to a reserved matter is to be determined by reference to, and you'll see the familiar words and the familiar test for reserved matters, and so on. So that's it's when that sort of issue, that sort of test is going to be in play, is the example given. And the point is that there are provisions, and the core point perhaps is that there are provisions in the Act which would require the question that is posed by the tailpiece wording in 1F, i.e. whether the functions of a body relate to a reserved matter, or that example of it in the explanatory notes, to be asked. And they arise under the Act because the Act requires them, in terms, to be asked and answered in those terms. And they arise by virtue of the Act, therefore, in that sense. And there are various examples of provisions in the Scotland Act where the boundaries of reserved matters and what is and isn't a reserved matter might give rise to issues of law requiring resolution by a law officer reference.
One of the lessons of the case law on devolution is that because the categories listed in Schedule 5 are often expressed in very general terms, there can be real difficulty in deciding whether or not a particular activity or subject falls within a category or doesn't.
Yes.
And so questions about reserved matters, if when we're just looking at those words, could very well include the sort of issue that the court had to decide in Imperial Tobacco, about how you classified a particular subject. I mean, is there any reason under the legislation why, if, for example, the Lord Advocate wanted to know, presumably for some practical reason, whether, say, particular topic was reserved or not, why she shouldn't ask the court to decide that question.
There are examples, which I'm about to take you to, in the legislation where exactly that can be done.
Yeah. Now, the background might be she wants to know in order to give advice on a legislative proposal.
Well,
I mean, the likelihood is that would be why she wanted to know.
yeah, well, that's more difficult then, because then you run into all the submissions I previously made, and I don't repeat, about the basic structure of the Act and how draft bills are dealt with. My point at this stage is that there are provisions in the Act which require you to know, for the purpose of the exercise or the limit of a particular power that is specified, whether something does or doesn't relate to reserved matters. Yeah. And my submission is that it's to those things, rather than simply opening the can of worms, as it were, with all the crossover and the cut across that I've identified earlier, it's to those matters that these tailpiece words refer. And one can see that in the structure of the Act there are provisions of that kind. My Lords, I was going to...
Well, if under Section 29 the Parliament can only legislate, if under Section 29 the Parliament generally cannot legislate in relation to reserved matters, and by virtue of Section 31 the Scottish Government can't introduce legislation which relates to reserved matters, then the question whether legislation relates to reserved matters is, I would have thought, a question arising by virtue of the Act. Now, she doesn't have to put a draft bill in front of a court, and this is, in the present case, is an extreme example, if you like, of a constitutional issue of the greatest significance. But there could be much more routine issues about, I don't know, restrictions on the sale of products, for example, where she might have a good reason for wanting to know. Does packaging of cigarettes, is packaging of cigarettes a reserved matter? Now, one could infer that if she's asking the question, it's probably because there's some consideration being given to legislating on the issue. But in terms of 1F, why shouldn't she ask that question?
Because, my Lord, the difficulty with that is that cuts across, I respectfully submit, the very careful and delineated structures of the Act that are designed to control that process. This is not a talking shop. This is not a jurisdiction created in this way by tailpiece wordings in paragraph 1F of Schedule 6. I mean, that would have enormous ramifications, not least constitutional, because the court is then being dragged at the behest of the law officers in all the devolved administrations into providing advice whenever they think a question is interesting, because they might or might not be doing legislation about it.
Well, that's one of the reasons why we declined to accept references in one of the Northern Irish cases.
My Lord, yes, but my submission is that when you're dealing with proposed legislation, the important fact is that Parliament has gone out of its way to specify how that gets done. And of course it leads to the position where if they can't make the statement, it doesn't get here, and I accept that, of course. But my submission is that that's an integral part of the Act. What you can't do is to construe those words in a way in which all of that gets thrown in the bin. They don't have to worry about any of that. They don't have to worry about putting it to Parliament, getting it sorted, getting it finalised, and then producing it to the court. They can simply go off with all the incoherences that only referring to reserved matters brings with it, if competence is the issue. Why do, I mean, my Lord has raised that point, but if that's right, why doesn't the reserved matters submission I made earlier cause difficulties for that line of thinking? Because, I mean, the Lord Advocate might be sitting there thinking, well, if I do the plain packaging on tobacco thing, that might be problematic in terms of reserved matters. It might also be problematic in terms of the HRA, because I'll be interfering with A1P1 rights, and I'm very worried about the fact that the proposed legislation I'm thinking about doesn't provide a right of compensation, and we might be taking away their intellectual property rights. So you still have to grapple with that incoherence. What all these provisions of the Act, I respectfully submit, indicate is that this isn't an uncontrolled scheme under which the Scottish Government can come and trouble this court with requests for advice, subject only to the court's discretion to refuse to do it. It sets up a jurisdictional set of structures and procedures which are specifically designed to ensure that when matters come to this court, this highest court, on a constitutional basis, they come with the bill in finalised form. And you can see exactly what's been done, those democratic processes have been gone through, or you have the devolution issue processes that you see set out in Schedule 6, but they're by and large to do with functions that exist or legislation that has been enacted. And so the question is there some meaning that can be ascribed to these tailpiece words, broad though they appear to be, which does not create that dissonance? And my respectful submission is that there is, because you can strew the words arising by virtue of the Act in a way that doesn't do damage to by or under, but simply says you've got to be able to identify the function, the specific time when reserved matters and reserved matters only are going to be interesting.
She can exercise the power in relation to delegated legislation, even on your argument, I think.
She can exercise the paragraph 34 power.
Yes. Issues under, in the tail end words of paragraph 1F, could arise in relation to delegated legislation, and she would be able to make a reference then, because your arguments about section 31 and so on wouldn't apply. And indeed, the examples you give us are of making an order in council or making a transfer order under section 63. So I mean, those are examples of delegated legislation.
Well, Lord, I think I'd be inclined to accept that unless I have a notional gown pulled, as it were, relatively rapidly. Yeah. But can I park that and think, just in case there is an issue with that? But even accepting that, that's simply an example of a case in which there is law on the face of the books, as it were, and there is then a question as to whether or not it does or doesn't raise a devolved issue.
Oh, does it have to be on the books? I mean, we're told here, for example, there could be a question whether Her Majesty is making an order in council within devolved competence. I mean, it would make more sense to ask before she makes it, or he makes it now, than afterwards.
Are you reading from a particular provision?
Yes, I'm looking at page 379.
I'm so sorry.
Where you just had us. Line, in the second paragraph, lines 4 and 5. Or indeed the next one, or whether a function is exercisable so that it may transfer by an order under section 3. So this is, I think, looking, I mean, obviously these are just explanatory notes, but they seem to be envisaging the question being posed in advance of the delegated legislation being made.
Yes, my lord. I think the answer that I would, sorry, I'm being stupid. The answer that I would give to that is that those seem to be examples of the first part of 1F.
Oh, I see. The exercise of a function.
About whether a function is exercisable within devolved competence.
Yeah. Yes. So in fact, there's nothing said here about the tail end words.
Yes. Do you see? So that's doing it broadly, but this is about the functions. So 1F is confusing because it's in two parts, and they're not relying on the first part, and those examples all relate to the first part. Yes. It's the second part that we're worrying about, with that contrast that it only refers to reserved matters.
Yes, I see.
And not to competence more generally.
It would be interesting to see how the tail end words have actually been used in practice.
Whether there has been a reference relying upon them in advance of this case?
Well, not necessarily a reference, but they're words which could apply
yes.
in raising, either the Lord Advocate raising proceedings or in the course of proceedings raised by some other party.
Yes, my lord, I'm not aware of that actual practice, but I've been straining to get a document that I haven't been allowed to hand up to you yet into the court. I hope it will assist. It's coming to you electronically, and I was told by Derek in no uncertain terms that the court didn't receive paper anymore. But I've only got it in paper, and it may be coming electronically, but...
We'll stretch a point. And,
Lord
Advocate's seen this.
Yeah, they were handed this morning. Can I hand up?
My desk this morning.
Copies?
Yes. Well, unless there's an objection to its being
and what is it? Because we have had some things added to our electronic...
It's the Scotland Act, section 23, 56, 58. It's called Supplementary Authorities Clip on behalf of the AGS. But it's a few other sections of the Scotland Act that are not in.
Yes.
And it's the Northern Ireland Act to which reference was made yesterday. So I hope it's of assistance in reaction to questions from the court rather than being
thank you.
wholly new and unwarranted material, as it were. There's 6 copies out there, thank you.
Yes, well, it's true we are a paper-free court.
I've got a bit of catching up to do on that basis.
We can receive the electronic version.
Well, I'm sorry, the electronic version is either with you or on its way to you, but it just may be easier to look at it now while I'm making the submissions. What these are examples of sections of the kind my Lord refers to. I don't know whether any of these have led to actual cases, but they're examples of the sort of thing that we've just been discussing. So if you look at section 23, this is the power of the Scottish Parliament to require a person to attend as a witness for the purpose of giving evidence. You see that from 23.1. And for present purposes, the relevant bit is 23 sub 6, where all the functions of a body relate to reserved matters. The Parliament may not impose such a requirement on any person in connection with the discharge by him of any of those functions. So they can't compel someone to turn up as a witness.
Does that come within the first part of paragraph 1F then?
Well, my Lord, I suppose it could, or it could come within both. But it's an example of a matter that specifically poses the question, within the framework of the Act, does this thing relate to reserved matters? But not otherwise. So they can use that power if it does and not otherwise. So you see the structure of it. And then in 35.1b, which is back in the main body of the Act, and it's page 144, you will see that there's a Secretary of State power to intervene in a legislative process if a bill contains, and it stops it being submitted for royal assent, if the Minister or the Secretary of State in question believes that it modifies the law as it applies to reserved matters. See subsection 35.1b.
And that's at page what, sorry?
Page 144, my Lord, sorry. So again, does it apply to reserved matters? That's in relation to a legislative function. And there's a similar power in 58.4, if you just go back to the little clip, in relation to subordinate legislation made or capable of revocation by Scottish ministers, if the same test as we've just seen in 35.1b is met. In the Secretary of State's view, the Secretary of State can revoke the subordinate legislation himself. And you'll see that the limitation is in 4b. 58.4b makes modifications of the law as it applies to reserved matters.
So these are all examples where Parliament has picked out from section 29
The reserved matters. Is using them to delimit or control the nature of a power. That's essentially
yes, and in which the other aspects of legislative competence would not be relevant in any event.
Wouldn't be relevant and aren't picked out for that purpose because they form no part of the controlling power provision. It's only in relation to reserved matters. 56.4, go back a page to page 4 of the little clip. where the general transfer of ministerial functions to Scottish ministers under 53 catches the power to establish, maintain or abolish a body which has functions which do not relate to reserved matters and also other functions which do, the power has to be exercised jointly by UK ministers and Scottish ministers. And you can see why in that circumstance clarification might be required from a court. Section 88 in this little clip, if you go forward to page 7, again, more complicated just as a context to work out what we're dealing with here, but it applies to, it's about cross-border public authorities, which are designated in orders, and it's got two relevant aspects. The first of them is in 88(2)(b). The United Kingdom minister must consult the Scottish minister if it intends to exercise in relation to a cross-border public authority a function which might affect Scotland otherwise than wholly in relation to reserved matters. Same idea. So the question is, does the consultation duty arise? And 88(6), which is similar to the power to compel witnesses, people to turn up and give evidence in the Scottish Parliament, but in this context, look at 88(6). Such an order may only specify a body, government department or office holder, which at the time when the order is made has, in addition to other functions, functions which are exercisable in as regards Scotland and do not relate to reserved matters. So it's essentially the same idea. And in relation to complaints of maladministration, over on the next page, page 8, 91 sub 3 sub D, any action concerning Scotland and not relating to reserved matters, which is taken by or on behalf of the cross-border authorities. So we submit that the references in the tailpiece wording is a reference to those sorts of provisions which specifically require reserved matters and reserved matters only as an idea to be considered. They're obviously important in the range of contexts, examples of which I've given. I'm sure there are others. But they're obviously important because the concept of whether something does or doesn't relate to reserved matters is specifically something which conditions the nature of the power or function, and so one can see why one would need a reference in some of those situations. But that interpretation of the tailpiece wording as referring to those sorts of things has the thoroughgoing virtue, we submit, of avoiding all of the substantive and procedural incoherences that I identified earlier, and avoids cutting across the careful scheme in relation to legislation of this kind, under Section 31 to come to that specifically, as to when and how bills need to have reached a state of fruition, as it were, in advance of a reference being made under the proper process prescribed by the Act, namely that set out in Section 3.
Which of those examples falls within the second half of paragraph 1F, as opposed to the first part of it?
Well, my Lord, my submission is that all of them do, because those are all questions arising by virtue of this Act about reserved matters. They're not the first part, which is, well, they may be included if you read devolved competence in that way, but they are all, as it were, tracking the wording of that tailpiece provision.
But
My answer is that they all do.
devolved competence is defined, I think, in Section 54, which I don't think we have.
I'm sorry, we should have provided that as well. You might have to help Mr. Habits to find it. Well, can I see, I don't want to stop making submissions about a provision I haven't got in front of me. Can I see whether there's anything to be added on devolved competence and its definition?
It does seem to be relating to something different. I don't want to take time to read it out, but it might be, given that we are interested in whether there are things that are covered by the second half of 1F and not by the first half, the fact that the first half relates to devolved competence and the
As a
second
broader idea.
as a different idea. I don't know whether it's broader or not. It might be helpful to...
Can I now
Yes.
check that and come back?
It's a very broad expression, devolved competence.
Oh, I'm sorry, I missed that.
Effectively, it applies the limits that apply to the Scottish Parliament in enacting primary legislation to other bodies, such as Scottish ministers, who also exercise devolved functions.
Yes, it's really sub 2, isn't it?
Yeah, well, it's 3 is really the wider provision. The 2 deals with subordinate legislation, and 3 is all functions other than in relation to subordinate legislation.
Although that's true, I wonder whether the significance of that, of either or both of those two provisions, 2 and 3, is that they effectively link the idea, as one might expect given the wording, of devolved competence to matters which would be outside the legislative competence of the Parliament.
Yeah.
But for the purpose of the exercise of functions of the executive rather than legislative functions.
Exactly so.
Yeah, but it has quite a major implication for your argument, because essentially, insofar as functions are exercisable by Scottish ministers, they can be outside devolved competence if the latter few words, put it this way, of your examples, I think at a quick glance, it's only powers exercisable by the Secretary of State in relation to reserved matters, which would not fall within the first part of 1F because the Secretary of State's powers are not limited by devolved competence.
But if there is a category which doesn't fall within that, then the point remains.
Yes.
There are other examples in the Act that show devolved competence or about reserved matters being used in that limited way that can't be brought within the first part,
yes,
even if they also... It might be that they're in both in relation to some of those examples.
It does give paragraph 1F, the final words, a far more restricted scope than on their face the words would appear to bear.
Well, that rather depends on which of the examples you plump within both or either. But my respectful submission is if you've got a choice between a relatively narrow reading of those tailpiece words and all of the dramas that I've gone through and I won't repeat, then it's a pretty straightforward choice, I submit. At least the argument is there.
Your point, I thought, was that this reference to arising by virtue of the Act about reserved matters reflects the fact that there are a number, as you've provided us with, of provisions of the Act that do generate questions about reserved matters.
And one wouldn't
using that term, whether or not they're also raising questions about devolved competence. Maybe they didn't want to.
I mean, you can see the mind of the draftsman working. I'm tracking the wording. I can see lots of provisions where the wording of the Act uses that as a unique concept. And maybe it gets crammed into some other concept as well, but it's being used in that way to cover those things.
The final words are any other question.
Yeah.
So it's any question other than a question about whether a function is exercisable within devolved competence.
Oh, Lord, yes, it's a discrete category. I entirely accept that.
Yeah. Well, so far it seems to be a category which has extremely few members, but you say, so be it.
I do. I don't want to say so be it too often, because otherwise you'll start not paying attention as you should to the strength of the submission that otherwise exists. Anyway, my Lord, those are the provisions I wanted to draw attention to. I hope not unhelpfully, because at least it shows the wording being tracked through the legislation, fully accepting any other question arises, but you've got something there that refers to to everything. And if there's an incoherence, if that's the point that's being put to me by Lord Reid, between the breadth of those words and the fact that the reserved category, if it's any other question, is relatively narrow, I respectfully submit that at least does provide some real workable sense to the words in a way that does not open up what I described as the bull point of incoherence against the Lord Advocate's case, which is that it is entirely unexplained and inexplicable that Parliament would have referred to reserved matters only in the context of concerns about whether or not you could introduce a draft bill under 31, where all of those concerns would base, or could base, entirely properly, in any of the matters referred to in subsection 2 of section 29. Just to finish this bit, Lord Stevens, I know, raised a question, and I know my Lord the President did too yesterday, about whether there was any wisdom to be derived from the position in Ireland, and we've tried to do a bit of research in relation to that. Can I give you very briefly the fruits of that research, for good or ill? Lord Stevens queried the suggestion by the Lord Advocate that reserved matters were a new concept, and you were right to do so, I respectfully submit. Section 414 of the Government of Ireland Act 1920 provided that the Parliaments of Northern and Southern Ireland did not have power to make laws in respect of reserved matters, which were then defined in section 9 of that Act.
I think it went back further than that, in fact, actually, because the colonial administrations also, I think, adopted reserved matters as a method as a drafting technique.
Yes. I think it was the same concept of reserved matters in a slightly different way in which the test was set up under that Act. It was in respect of reserved matters rather than relating to. Yes. So it was slightly tighter, but it doesn't bear on the point that you were interested in. The concept of reserved matters was also used in the Northern Ireland Constitution Act of 1973. Both of these have now been superseded, so we haven't provided them to you. But Northern Ireland Constitution Act 1973, the Northern Ireland Assembly was required to obtain Secretary of State consent to measures it passed dealing with a reserved matter. They were then defined in Schedule 3 of that Act. Lord Reid then asked about whether or not there were terms, or about the terms of the equivalent provision to 1F in 1 sub D of Schedule 10 to the Northern Ireland Act. That's the corresponding provision to 1F. As we noted in footnote 3 of our case. I'm afraid we've drawn a bit of a blank here because we haven't been able to identify any available contemporaneous explanatory notes or notes on clauses, or indeed any other documentation relating to the bill that elucidates the tailpiece wording. And nor have we been able, I'm afraid, to find anything in Hansard that bears on any of that. But I suppose the most that can be said in relation to those provisions of the Northern Ireland Act is that they raise essentially the same issue. We don't suggest that there are materially different words in the Northern Ireland legislation. We respectfully agree, if this was the point being made, that the same issue arises in relation to Northern Ireland. And just in case anyone felt we were leaving Wales out of the equation, we had a bit of a think about the Welsh legislation. And as we understand it, in the Welsh legislation, there is no 1F equivalent. Now, why that should be is a matter shrouded in the mists of history. I mean, it may or may not be related to the fact that it was a conferred powers model, but we haven't been able to identify any equivalent provision in Wales. So there's a slightly strange mismatch between
the structure of the Act.
The structure of the Act is very different, and maybe that's the explanation of it. But there isn't an equivalent in Wales. So I hope that at least tries to chase down some of those issues. Okay, for all of those reasons, sorry it's taken a while to get through them, but the arguments are somewhat convoluted, given the structure and terms of and the complication of the provisions in the Act. That's what we have to submit about jurisdiction and discretion. Of course, we are, by which I mean you are, where you are. The court wished in its permission consideration, it wished to examine, if that's the right way of describing it, it wished to examine all of the circumstances, including the substance of the question referred together, see page 35 in the electronics for that decision as to how this reference should proceed, with all of the issues being thought about and determined by the court together. Of course, there are a variety of potential outcomes in relation to and strengths of views that might be formed as to the competence question or the reference question, to which I'm going to come directly. The court may consider that there's a very clear answer to that reference question, and that, to come back to a point that my Lord Stevens was putting to me earlier, is it really realistic to suppose that the essentials of this are going to change? And we see the force of that. The court may consider that the answer would inure, if it's clear enough, in relation to any bill with a subject matter of this kind designed to set up this sort of referendum, and it isn't going to turn on the intricacy of the individual legislative provisions that might or might not sit in a draft bill. And if that is so, if the court does reach that position of clarity, then we can respectfully see good sense in the court saying so. But the jurisdiction issues are of broader significance, which is why I wasn't prepared to accept the entirety of the point my Lord Stevens was putting to me yesterday, because these are issues of general interpretation that might apply in relation to a very simple bill, or in relation to no bill, or in relation to a bill which is extremely complicated, and the same essential interpretive exercise would have to be grappled with. So that's why I've taken a little time to go through some of that detail. My Lord, my Lady, unless there were further matters on which I could seek to assist in relation to jurisdiction and or discretion, I was going to move on to the reference question.
No, I think you've given us plenty of food for thought.
So the reference question. Just by way of introduction, the basic approach we respectfully submit to how you as a court go about approaching reference questions is clear from the case law. You interpret the Scotland Act in the same way as you would interpret any other statute. The aim is for a, quote, consistent and predictable interpretation so that the Scottish Parliament has a coherent, stable and workable system within which to exercise its legislative power. That's a quote from UNCRC at paragraph 7, page 911 in the electronics. I don't invite you to turn it up because of the lack of controversy about that proposition. The extent of that legislative power is, of course, as the court has repeatedly made clear, derived and only derived from the statute which creates the Scottish Parliament. The reservation in question deals with the Constitution, Schedule 5, paragraph 1, that's the relevant title, and it sets out, quote, aspects of the Constitution, see Schedule 5, paragraph 1 on page 183, that are reserved. It's for the UK Parliament alone to legislate for matters relating to those constitutional arrangements. One of the, quote, aspects of the Constitution that is referred to is the union of the kingdoms of Scotland and England. That was described by the Supreme Court in the Continuity Bill case at paragraph 60, page 846, as, quote, one of the fundamental elements of the Constitution of the United Kingdom. So the only question is whether the provisions of the draft bill as presently constituted relate to that part of the United Kingdom's constitution, in other words, the Union. And I reiterate that the reservation is of the Union, not the dissolution of the Union. An act of the Scottish Parliament which relates to maintaining the Union would be just as outside legislative competence as one which relates to dissolving the Union. And my submission is that there is the clearest possible answer to the question that Schedule 5, paragraph 1 poses, whether or not it relates to. I wanted to start very briefly with the principled approach that the court takes to those questions, and in particular to focus on the principled approach to the concept of relating to. You may not need much on this because might be thought you don't need to engage too much in the fine graining of those principles, given the clarity of the answer. But 4 points on the principles, if I may, from which we say the answer to the question inevitably flows. Firstly, the basic analysis involves asking whether the scope of the subject matter of the relevant matter reserved by Schedule 5, asking what the scope of that is, and then asking whether the provision in question relates to that. See our case at paragraph 65 for the references for that proposition. Some of the cases turn on the first question, some on the second. Here there's no real doubt about the scope of the reservation. The issue relates to the second question and whether the draft bill relates to it. So that's the basic analysis, that's the basic stages of the analysis per the case law. Secondly, the question whether something relates to a reserved matter, so as to be within or outside competence, is a question to be determined applying section 29(3) by reference to, quote, the purpose of the provision having regard, amongst other things, to its effect in all the circumstances. So purpose is the driving and predominant thing in that mandatory canon of interpretation. I wanted to focus first on purpose briefly and then on effect, taking up that language. Purpose, says the case law, requires focus on more than can be discerned from an objective consideration of the effect of the terms of the provision. More than can be discerned from an objective consideration of the effect of the terms of the provision. That's paragraph 50 of the Agriculture Bill Wales, per Lords Reid and Thomas at page 666, a statement that was then specifically endorsed in Christian Institute, Lords Reid and Hodge and Lady Hale, Christian Institute, paragraph 30, page 791. And I emphasise that because section 29(3), as is evident from its terms and as is evident from that description of the principled approach to purpose in those authorities, is not a pure objective question of statutory interpretation. Statutory interpretation is the exercise of seeking the meaning of the words used by Parliament by reference to, amongst other things, its purpose. Here, as it were, it's reversed. You're seeking the purpose of the legislation from, amongst other things, the meaning of the words. That's a fundamentally different exercise. It's even a different exercise, I respectfully submit, from the statutory interpretation exercise that would be engaged under an HRA or ECHR challenge, although that's some way down the line towards this 29(3) principle. And as such, because that's the basic nature of the exercise that the court is enjoined to undertake under 29(3), that does entitle and may require a court to consider the aims of those who introduce the bill. In Agriculture Bill, for example, the purpose and effect derived at paragraph 54 from both the purpose of those introducing it, that's the bill, and the objective effect of its terms. See paragraph 54, page 667. In Martin and Most, Lord Kerr held that the statements of those responsible for the legislation purporting to identify the reasons for its enactment were relevant to the section 29(3) exercise. See paragraph 162 of Martin and Most at page 441. So 162 is the paragraph, 441 is the electronic reference. In the Inner House in Imperial Tobacco, Lord Reid held at paragraph 122, page 589 of the authorities bundle, the focus is primarily on why the provision has been enacted rather than what it does, and the motive and policy of the legislature is relevant. So you are often using documents accompanying the legislative process, as the case law also makes clear. We've given you a series of examples of that being done in our case at paragraph 13, and Martin and Most and the Agriculture Bill cases provide further examples. I think Lord Stevens asked yesterday whether or not documents such as party manifestos, etc., can be admissible, and we respectfully submit that there's no reason in principle why not. You are seeking under this set of provisions to identify the purpose of a bill, including by reference to the purpose of those responsible for it. That's as it were, the change that section 29(3) makes to the ordinary approach to statutory interpretation. And it might be thought that the core question in relation to purpose, that part of section 29(3), is helpfully encapsulated at paragraph 43 of the Supreme Court's judgment in Imperial Tobacco, para 43 at page 650 of the electronic bundle, the core question being, what are the provisions really about? So far as effect is concerned, to move to that concept, that is a reference, as Agriculture Bill at paragraph 53, page 666, makes entirely clear, that is a reference to, quote, legal and practical effects. Legal and practical effects. You have to look at the realities. And a good example of this, it might be thought, is Imperial Tobacco itself, where the legal effects were the prohibition of the display of tobacco and on its sale in vending machines, but the purpose of those effects, what they were really about, was the promotion of public health. There is, of course, no dispute that practical effects ought not to require undue speculation. That's just a basic principle of common sense. But a natural inference is perfectly permissible. In Imperial Tobacco in the Inner House, Lord Reid considered the short-term practical consequences, as he put it, of the prohibitions at paragraphs 133 to 134, page 592. So 133 to 134 is the paragraph, or are the paragraphs, and 592 is the electronic reference. And those short-term practical consequences in the example of Imperial Tobacco were they would reduce sales and were thereby consistent with the public health purpose. That was the basic practical, short-term practical consequence that was identified. And the legal and practical effects were also considered in Continuity Bill, at paragraph 33. The retention of EU law after exit did not relate to the reservation of relations with the EU, because the legal effect of those relations would be zero, because they only took effect after exit with no relevant relations left, and there was no practical effect on the conduct of exit negotiations. So again, both of those aspects, practical and legal, being...
That's paragraph 33 of page...
Paragraph 33,
sorry.
838, thank you.
Thank you very much.
Sorry.
Thank you.
So that's the second proposition, determined by reference to the test set out in 29(3 as exemplified and explained in the case law. Thirdly, to come closer to the nub of the dispute, it appears, of principle between us, relates to is, as Lord Walker put it in Martin and Most, finely modulated language which carries the ordinary meaning of more than a loose or consequential connection. Finely modulated language is in para 46 on page 405, and more than a loose or consequential connection, that well-known phrase, is Lord Walker at paragraph 49 of Martin and Most, page 407. And of course everyone accepts that relates to must have some limits, or must, as Lord Kerr put it in Martin and Most at paragraph 159, page 440, must be suitably restrained, because otherwise section 29(4) of the Scotland Act would be unnecessary. So not everything which affects, to take the word, a reserved matter, however slight, indirect, or remote the effect may be, taking those words from Lord Reid in Imperial Tobacco at paragraph 120, so not everything which affects a reserved matter, however slight or indirect or remote the effect may be, 120 at page 588, Lord Reid in the Inner House in Imperial Tobacco, is covered. What you need is more of, and I underline notionally more of, a direct connection, to come to that phrase, much beloved of the Lord Advocate. What the case law makes clear is that in some circumstances you need more of a direct connection than everything which affects a reserved matter. That is essentially what Lord Mance is saying at paragraph 27 of medical costs, which you were taken to yesterday, and I don't go back to it because you'll be very familiar with the passage. That's paragraph 27, Lord Mance, page 735 in the electronic references. We do, however, invite you to note when you go back to those paragraphs, particularly 25, 26 and 27, we do invite you to note that he was not laying down direct connection as a test. He was merely using that idea to indicate degrees of connection sufficient to come within the concept of relates to. And he was then applying that to the facts of the individual and particular case that he was then considering. And the reasoning is, as you see, summarised in the relevant parts of that judgment. You will note, just by way of basic structure of that part of the judgment, that he'd already set out the Lord Walker test, if I can put it that way, more than a loose connection. He'd already set that out in defining and describing the principles at paragraph 25. And he noted specifically in paragraph 25 some of the many cases in which that language and no other language had been recently and repeatedly approved and applied by the court. That's this court. And he says he's then going to apply the same test to the Welsh legislation he was having to consider. And his conclusion at 27 is that section 2 of the legislation in question was, had at best an indirect, loose or consequential connection. It's clear from that recitation that he wasn't intending to impose some reverse test that the connection must be direct. He'd set out the principles. If he was going to alter the principles or thought that was what he was doing, then the obvious and natural place for that to be done as an amendment to or alteration of or tightening of the Lord Walker language was in paragraph 25 when he was dealing with the principles. He didn't do that at all. And indeed, given that it was Lord Mance who was producing the judgment, it might be thought that if he was intending to gloss Lord Walker's test, as the Lord Advocate appeared to submit yesterday, one would have expected him to say so in pretty clear terms and explain why he was doing that and why that was an appropriate thing to do, having regard to the structure or content or the purpose or whatever it was of the Scotland Act. It would have been a thoroughly material departure if he'd moved from the position of Lord Walker to a position which requires a direct connection as part of the inherent in or as limiting relates to direct connection. He did nothing of the sort. So we respectfully submit that that submission of principle by the Lord Advocate is untenable, effectively, on a true and fair reading of paragraphs 25, 26 and 27 of Lord Mance's speech, and indeed is perhaps its main significance as a submission is that it indicates implicitly that my learned friend recognises that she has to make that submission in order to make the rest of her argument work. She has to win that argument of principle. If she can't win the argument of principle, the case becomes a great deal more difficult in its later stages. The fourth submission of principle that we invite you to have a think about is that the provision in question does not have to modify the law applicable to the reserved subject matter in order to relate to it. So there doesn't have to be a legal effect in that sense. That's the point that's made by Lord Reid in Christian Institute at paragraph 33 and at paragraph 63, pages 793 and 804 for those two paragraphs, 33 and 63.
Paragraphs again, please.
33 and 63 on pages 793 and 804 respectively. And it's evident that that is so, not least from the statutory language, from the contrast between relates to in section 29(2)(b) of the Scotland Act and 29(2)(c), page 129 of the bundle, referring to a breach of restrictions in Schedule 4, paragraph 2, which includes provision or preclusion against modifying the law on reserved matters. That was the basis for the point that Lord Reid, Lord Hodge and Lady Hale were making at paragraph 33 of Christian Institute. So those are the 4 points I wanted to emphasise by way of submissions on the principled approach to the concepts that you're going to have to grapple with. So what then of the answer here? We make 3 submissions as to the application of those principles here. Firstly, the subject matter of the matter reserved is the aspect of the United Kingdom Constitution that is the Union. It's entirely unsurprising that that aspect of the Constitution that is the Union is reserved to the UK Parliament. And that is because it self-evidently affects the whole of the United Kingdom. The impacts and effects of Scottish independence would be felt throughout the United Kingdom. All parts of the United Kingdom have an interest in that issue, not just Scotland. And it's obvious why it's reserved to the United Kingdom Parliament. It's of critical importance to the United Kingdom as a whole. The Union is the constitutional foundation of the modern British state. It's equally obvious why the Union could not be a matter over which the Scottish Parliament has competence. It would be fundamentally at odds with the purpose of devolution to grant powers to a Scottish Parliament within the Union. But the point about it being of that ilk, because it affects the whole of the United Kingdom, was precisely the point that was made by Lord Hope in Imperial Tobacco. That's the moniker, as it were, for whether or not it's reserved and how you judge whether something is reserved and what the limits are. That's the point made by Lord Hope in Imperial Tobacco, paragraph 29, page 45 in the bundle. And that was then cited with approval. That very point about affecting the whole of the UK was cited with approval in Christian Institute by Lord Reid at paragraph 28. See for that purpose page 790. And indeed, to those references we add Lord Hodge's recognition in Muan at paragraph 17 that a referendum of this kind would be, as he put it, a very important political decision for both Scotland and the rest of the United Kingdom. See paragraph 17 of Muan at page 684. And of course, Muan was in the context of the 2014 referendum. That's the first submission. The second submission is that the key provisions of the draft bill are self-evidently, squarely and directly about the Union. The draft bill, if introduced and passed, would set up a referendum that is, as my learned friend the Lord Advocate was positively at pains to emphasise by reference to Dicey, who is somewhat ambivalent on some of these issues, but on this obviously correct. That is the most targeted form, to put it neutrally, of seeking electoral views, as this court is well aware from all of the Brexit issues that arose. The referendum which the draft bill purports to legislate for would be the very question whether, in the view of those participating, the Union should continue, whether Scotland should become an independent country, to take the referendum question proposed. The Union, if that happens, would end. You don't need minutely to cut purpose and effect. They are both obvious here and they coincide. But for good measure, if you're asking the question that I identified as a neat summary with respect to what the purpose aspect of 29.3 is about, what are the provisions really about? They are about seeking the views of those entitled to vote in the referendum for the purpose of furthering the Scottish Government's avowed aim to end the Union and to make Scotland independent of the United Kingdom. So the Lord Advocate's case has to be that legislation which would directly regulate a referendum on the very subject matter that is reserved does not even relate to that subject matter. That, we respectfully submit, is untenable as a submission. The Union is the very and the sole object of the referendum that the bill purports to set up. That's why it's being put forward. And that is why, no doubt, the explanatory notes, to which we've already made reference, provide precisely this sort of legislation, setting up a referendum on Scottish independence, as the paradigm example of proposed legislation that is not or would not merely be not within competence, but so clearly not within competence as to render it impossible to use the strong interpretive principle in section 101, which is, some of you will recall we considered in some detail, or you considered in some detail in UNCRC. See for that purpose page 376 in our case at paragraph 81. Thirdly, third submission, the fact that the referendum is not self-executing does not support, still less mean, that the draft bill does not relate to the Union. Of course, the position is that even if the referendum had been within competence, the position would be as summarised by Lord Newburger in Muan at paragraph 47, page 694. Remember the bit where he said everyone will have to vote with their conscience because it's not self-executing. So it will still be a matter for the Westminster Parliament to determine whether or not to do anything about that. That doesn't mean that the bill doesn't relate to the Union. The draft bill will be legislation directly to do with and intended to create effects on the constitutional arrangement of the Union. It relates to the Union whether there is immediate and direct legal effect flowing from that result or not. The bill, if it were to be introduced and became an act, would provide the legal basis for the referendum. And that is why there has no doubt in recent days been repeated emphasis by the First Minister on this court's process as being one of invitation to you to, as she put it, pave the way for a lawful referendum. Evidently, the purpose of the draft bill is not just to have an opinion poll, but to seek to take advantage, political advantage and other advantage, of this being a referendum conducted under the authority, whatever its legal effect, of an act of the Scottish Parliament. With, we would add, no doubt a suggestion that that decision, were it to be held to be within competence, had in fact been devolved by Westminster to the Scottish Parliament, at least to that extent, and thus creating further weight to some implication that something should at least follow from a positive outcome of the kind which the Scottish Government no doubt hopes for. To focus slightly, but only slightly, more broadly, focusing on the referendum that the bill purports to provide a legal basis for, the Scottish Government are evidently setting that process up for a purpose. It is entirely clear, if one's adopting a realistic, any form of realistic approach to this, it is evident that they consider and intend that the referendum will further the cause of independence. That's no doubt why the draft bill would have been introduced, but for the intervention of the Lord Advocate's view under Section 31, would have been introduced and would have been supported through the Scottish Parliament by the Scottish Government as presently constituted. And if it was answered in the way that they no doubt hope, it's perfectly obvious that they will regard that as an important step towards the termination of the Union, which they will present as a strong and targeted democratic mandate for their cause. In Lord Reid's language from Imperial Tobacco, one only really needs to look at the short-term practical consequences of the referendum outcome either way, to see the link to the Union. And indeed, there's no secret about any of this. See the references that we've given you in our case at paragraph 75 and that are set out in the Lord Advocate's own case at paragraph 109. And those sorts of matters are relevant, as I've explained, to identifying the purpose of the bill. So the First Minister's statement to the Scottish Parliament in connection with this reference on the 28th of June makes clear that she wishes to introduce and pass the draft bill to further the cause of independence. See page 6499 for that purpose. See also another Scottish Government Minister's official comment in connection with this reference to the same effect. See page 6497. See the most recent SNP manifesto, if you need that for the entirely self-evident factual proposition for the Scottish Government 2021 elections at 6361. The Lord Advocate goes as far as to say, or to submit, that the legal effects of the draft bill are, as she put it in her written case and has put it to you orally, relevantly nil. Even if that is accurate, that is both an ironic and an irrelevant plea. It is not even an accurate plea. There is a need for statutory authority in order to authorise the significant public resource that would be needed to conduct a referendum. Clause 4 of the bill, page 14, needed to apply the Referendums Scotland Act of 2020 to the conduct of the referendum. Section 7 of that act needed to give power to appoint a chief counting officer for the referendum, whose functions are then set out in Section 9. Section 11 of that Act, that's the 2020 Act, authorises the chief counting officer to recover the cost of the referendum. And to give some insight, the Scottish Government predicted in 2010 the first referendum would cost in the region of £9.5 million. See 5777 in the electronic. At one point in our oral submissions yesterday, the Lord Advocate asserted that the referendum needed to have a legal effect on the Union to be sufficiently directly related. Well, she's wrong about directly related for the reasons I've given, but she's also wrong to adopt a test which requires a legal effect. That is, we submit, to fall into the error identified by the Supreme Court in Continuity Bill at paragraph 51 of conflating a Schedule 5 reservation with a Schedule 4 restriction on modification. If all that the United Kingdom Parliament was seeking to achieve in the Schedule 5 paragraph 1 provision was to prevent the Scottish Parliament from legislating to end the Union, it need only to have listed Article 1 of the Acts of Union in paragraph 1 sub 2 of Schedule 4. It didn't do that. As the Court put it in paragraph 51 of Continuity Bill, page 843, quote, when the United Kingdom Parliament decides to reserve an entire area of the law to itself, it does so by listing the relevant subject matter in Schedule 5. That's the point being made by the Supreme Court in Continuity Bill. And here it is evident that the United Kingdom Parliament has reserved the entire area of the Union to itself. And that must include, we submit, must include laws enabling referendums about whether the Union should continue. The Lord Advocate said that questions of legislative questions could be debated by a whole variety of bodies, including the Scottish Parliament, even if those debates related to reserved matters. My submission is that it doesn't assist the statutory question of legislative competence to look at whether or not the Scottish Parliament holds debates to discuss and may indeed pass motions about matters on which it could not legislate or whether the Scottish ministers could negotiate with the United Kingdom government about the terms of changes to the competence boundaries when they do not have power to do the things that they wish to do. The 1998 Act and the competence limits established in Section 29 set careful controls on the exercise of legislative powers, that views may be expressed about reserved matters, and Scottish ministers may listen to them and seek them and reflect them to the Scottish Parliament or the UK government is entirely unsurprising, but also entirely uninformative for the purpose of this reference, which is concerned with legislative competence. I've focused on the Union, and I've nothing really to add in relation to the separate reserved matter of the Parliament of the UK, which is dealt with in our case at 86 to 88 and engages essentially similar points. I also don't propose to engage in any detail at all with the written response that we've made to the intervention of the SNP, and particularly to the reliance which is there placed on the principle of self-determination in international law. I've nothing further to add orally. That is a set of arguments which we respectfully submit and have submitted in our written response, fails at almost every analytical stage. So in conclusion, we respectfully invite the Court to agree with the Lord President in Keating's at paragraph 66, into which paragraph one has to interpose, one suspects, at least a drop of irony, that the answer to the question whether such a referendum bill will be within competence is not too difficult or might not be too difficult to discern. We agree also, I should make explicitly clear, with the Lord Advocate in considering herself correctly unable to support a within competence statement. This is, to put it at its lowest, a strange reference legally. It comes to the Court in circumstances in which the Scottish Government has not even felt able to introduce a bill into the Scottish Parliament on the apparent basis that their own law officer is unable to say that the bill will be within competence. And it comes to the Court in circumstances in which it is perfectly obvious that the Scottish Government want to produce legislation in Scotland in order to advance, as they see it, their avowed political agenda of independence and thus ending the Union. And yet, in the same breath, they seek to assert that their draft bill does not even relate to the Union. If, in this context, this draft bill does not relate to the Union, it requires an interpretation of the words relates to, which is contrary, we submit, to all of ordinary language, this Court's consistent case law, and common sense. And that is neither a coherent nor, we submit, an attractive place for them to be, or to submit that the Court should find itself in. So for those reasons, if you get to this stage, we invite you to answer the reference question in that way. My Lords, my Lady, unless there were further matters on which I could seek to assist, those are my submissions.
No, thank you very much, Sir James.
Great.
Lord Advocate.
Yes, thank you, Lord. I wonder, Lord, I note that it's 1:45.
Yes, and
in the course of Sir James's submissions, I was given for the first time an understanding as to why this document was produced this morning for me at 10:30. So I wonder if I might be given the opportunity to reflect on what he said over lunchtime and to come back at 2 o'clock and hopefully complete matters by my response, and it will be more focused than I could probably do at the moment.
Yes, that's fine. I should say that we've also received electronically during the course of the morning, in addition to Sir James's additional material, also additional material on behalf of the Lord Advocate. I don't know if Sir James has this. As you've been on your feet, you won't have been able to see it. If new material is going to be referred to in a reply, then we'll have to give you an opportunity to respond.
Very grateful. Someone might provide me with a copy of whatever it is.
I think the copies have been given, my lord, and the document, I think, relates to the point that was raised yesterday about the process involved in a private member's bill.
Yeah, thank you. So if we resume at 2 o'clock, will that give you sufficient time?
Yes, that does. Thank you.